Welcome, everyone, to the first in our series of three LinkedIn Live episodes on making your biopharma IP portfolio investment ready. We are talking from EIP, which is an international IP and patent law firm with offices in the UK, Sweden, Germany, and the US. My name is Gareth. I'm the head of our biopharma, pharma, and chemistry group. With me is
I'm Tim Belcher, and I'm a partner in Gareth's group.
our talk today is all about building an investable IP portfolio in the biopharma sector, with the emphasis on how to build it with the key factors. Tim has a great deal of experience in the biopharma sector and has in-house experience, which is invaluable when we deal with our clients in this area. We're going to talk about three main factors. They're not the only factors, but they're very important, and it's who, what, and when. So, Tim, could you run through for us who? What does that mean?
So, I mean, who's crucial, and it stems initially who is the inventor, because the inventor is where IP ownership starts. It tends to move on through to companies such as applicants, and there may be agreements between companies which dictate who the owner is. But the first question is, who are the inventors? Because that's where the IP originates, the IP ownership. This is a very collaboration-rich sector. A lot of biotechs or small pharma companies will have joint ventures or partnering with bigger enterprises. There is a big move towards global teams and the use of CROs to do research. And all of these collaborators may be generating IP. And so it's important to identify who they are, what they're generating, and to make sure that the overarching agreements, the contracts between these different entities, dictate where the IP ownership resides. And without that, an investor might be put off because the IP is not wholly residing in the company they're investing in.
And is it safe to assume that the rights will automatically transfer to the applicant in all these cases?
The best practice would always be to have a written contract signed by both parties. That's the sort of the cast iron way to make sure. Otherwise, you get into local law, and how rights transfer depends on which country you're based in. There are also various different types of rights. So a lot of small biotechs are spun out of universities. The biotech may well have a license from the university and not actually be the owner. But if that written license contractual agreement is there, if the company has the exclusive right to utilize the IP, that might satisfy an investor. But without all that documented and without the full chain of title from inventor through to end company, an investor is going to be put off or at least concerned that the IP portfolio is not wholly owned by the party they're investing in. And that can kill a deal. That has torpedoed many deals that you and I are biting at.
And in these days, with, like I say, very collaborative, very team-based working, plug and play across the world, it's more and more important to make sure all these things are dealt with before an application is filed. Because in some cases, it may be possible or very difficult to fix afterwards.
Indeed. And also, I mean, knowing, this goes onto where, which wasn't one of your key topics, but knowing who your inventors are and where they're based can restrict where you're allowed to file a patent application. And if you get that wrong, it can invalidate it in certain countries. Yeah. And also, going back to the who and the inventors, if you get your inventorship wrong, don't give it the due diligence it needs, it can render your patent invalid in some countries, and most notably in the US, which is obviously a key market in this sector.
Yeah. So it's best to check all these things, get all the paperwork done ahead of time rather than leaving it very near the filing day. Yeah.
And I suppose the follow-on from that is, if IP is transferred or acquired, often that can be recorded at the patent office. So if there's a change of applicant, that can be recorded at patent offices around the world. It's also best practice to do that to make your IP portfolio resilient.
Yeah. Investors are going to make sure that they know who owns the IP they're buying and the inventorship is correct.
Yeah.
So that leads us on to the next one, which is what? What do we protect when we build an IP portfolio?
So in this sector, most of the IP will be in patents. Trademarks and other things aren't quite so key. But there is a lot of potential to file patents. The most important case will usually be that protecting the novel entity, the novel chemical and novel biological entity. That's the crown jewels in any IP portfolio for a company of this working in this sector. But on top of that, there are a lot of other filings that can be made, secondary filings, which can be useful because they're filed later. They can extend effective monopoly term beyond the patent term of that NCE or NBE filing. Examples would be formulation, polymorph, or enantiomers, and those are all sort of structural things. But there are other areas that could be protected, such as dosage regimes,
Patient groups, further indications.
Yeah. And having sort of a thicket of patent rights built up from that initial first filing and all the secondary filings following on can effectively close competitors out the market for longer than that initial term, which can hugely increase the potential return on investment and the investability of your IP portfolio and company overall. The other thing I'd say is on the first filing, the novel entity filing, there are things you can do in that space to improve your position, subject to budget, I would add. But a common strategy which we employ is to have more than one filing directed to the novel entity, at least in big jurisdictions, such as the US or Europe. If you can do that, you can have one narrow, rock-solid, what we call litigation-grade patent, which covers the asset. That is very hard to validate. It's not broad, and it can usually be granted fairly quickly, which can also smooth prosecution worldwide for similar patents. So in addition to those narrow patents, I think in big jurisdictions, it's worth having a second application. We can have a big, broad application which seeks to protect both the lead asset, but also the space around it, to stop competitors coming close to your lead asset or your backup compounds. And that broader case can also cover backup or secondary or compounds of secondary interest, which are worth protecting at least early on, pending tox data, for example.
So if you get that fast granted patent in the US, for example, are there any ways to keep your options open to give an investor or an acquirer the freedom to get more IP in that country?
Investors also often place a premium on having pending applications when they invest. That gives the investors freedom to take their IP portfolio in the direction they want. So it is possible to sort of what is called file a divisional application and keep applications pending in major jurisdictions.
Yeah.
I suppose a last point I would make, going back to that backup compounds and secondary filings, is whilst a broad application around your lead asset can close off some space, if your backup compounds are a little bit further away, it can be worth having more than one novel entity filing, at least early on. As your data progresses, as you get tox data, druggability data, it may be that the lead candidate is viable, and those backup compound IP portfolios shrink or get dropped as the value for money they provide declines. But early on, protecting the most interesting space, but also backup spaces with filings is a valid and potentially important thing to do.
And that sort of leads on to the last point of when. So it's all very well, Amy, to have all this different sort of types of patent applications filed. But what about timing? When do you choose to file them?
That's the money question. It's not an entirely straightforward question. There's a lot of factors in play. But in a sector like biopharma or medical devices, where there are regulatory hurdles before you can launch, timing your IP against that anticipated regulatory approval is vital. For a biopharma product, marketing authorization usually takes 10 to 15 years to come by. A patent term is 20 years, and most investors, the sort of industry ballpark is that you need 7 years of exclusivity to recoup investment. So with a 15-year marketing authorization, a 20-year patent term, and 7 years desired exclusivity, you can see that there's competing factors in play. In an ideal world, ignoring any other outside influences, you file your patent application around the time you identify your lead candidate. I heard this phrased at a session I was at a few months ago as when you finish research, but before you start development. So you identify your lead compound and you know what you're taking forward. That's the time to file your IP. That way you can be sure your IP covers your lead, it provides value for money, but it also provides hopefully the maximum patent term post-marketing authorization.
So in some areas, it is very crowded. Lots of competitors all working in the same sort of area at the same time. So does it make sense to, as soon as you have an idea that a certain area might be of interest, to file your application as soon as you can?
It can do. So a crowded space, if you anticipate others filing in that space, they could end up finding a case that's a problem for you, be that it compromises the patentability of your idea or it's a freedom to operate issue. So they are claiming space and you can't operate. All that said, an entirely speculative application comes with problems. Patent offices want to see an invention substantiated, or they want data that proves the credibility of the invention. I can't claim that aspirin is a cure for all ills because I don't have that data, and the patent office would challenge that. So you need a patent application with at least bare bones data before you can file. There are ways around that. So once you do your first filing, you then have 12 months to fully substantiate it before you file in other countries. So that if you're 12 months out from identifying your lead compound or 12 months out from having your data, you can file somewhat speculatively at that point.
Yeah.
But you do need to have confidence that you can live up to that timescale.
Yeah.
And another reason to file early might be if you're attracting seed investment. You might not have the money to go into the lab and generate that data yet. So at that point, the notion of waiting till the end of research and starting development isn't an option. And that sort of end of research, start of development filing point is, as I said at the time, it's an ideal, excluding outside influences, but commercial realities will often dictate filing sooner.
Yeah, and one of those, of course, is filing before a company discloses details of their invention, which is something we are very aware to.
Yeah, we've advised on deals in the past where potential patent applications were briefer than might have been ideal, but that's because they were talking to us and they needed to disclose the invention to an outside party.
And so properly substantiated.
And substantiated in the subsequent 12 months to form good IP.
Yeah. That's great. So that's a really interesting discussion on the three main factors of who, what, and when. There's more factors involved, clearly, in building a strong IP portfolio, but they're three of the most important, I would say.
I agree. And I think the how and the where is also important. I mean, the how, I think we could briefly touch on, which is how can an IP advisor help? I think historically, a lot of biotechs would approach an IP advisor and say, I'm ready to file my patent application. Can you draft this for me? And I think we challenge that as a model to operate on.
Yeah, we aim to be very proactive. We're not a passive IP firm, so we believe in being part of the company to help them reach their goals by being very proactive, responsive.
And a number of our team, I mean, I have in-house experience, and that's true of a lot of the team. And we aim to provide our clients with that in-house level of service. So we get into the client and we're driving the IP portfolio forward alongside the business plan, rather than simply reacting to an email saying, please do this. I feel like we're the experts in this sector, we're the advisors, and we want to advise, we want to help clients on their journey rather than just exist at the other end of an email.
Okay, that's great. That's quite a brief introduction in how to build an investable and strong IP portfolio in the biopharma sector. Hope you enjoyed it. Please do get in touch if you need any assistance or advice. We'd be very happy to talk to you.
So the next episode in this series will be about strategic moves to make before an investment round in the biopharma sector. We have lots of experience in that, both supporting investors and the companies seeking investment. So we hope you'll